Did TikTok star Jooles Lebron lose her $1 million phrase, very demure, very mindful? She quickly gained millions of followers with her viral videos and viral phrases. But will she use the right to use them after trademark applications were filed? As a trademark attorney for 15 years, I've helped thousands of brands get and contest trademarks. And in this video, I'll cover who owns the rights to the slogan and who will actually win the battle. Will it be LeBron or those other vultures that filed? Let's see what happened first. Immediately after LeBron went viral with her TikToks and appearing on Jimmy Kimmel, some guy named Jefferson Bates filed a trademark application for very demure, very mindful related to advertising, marketing, and promotional services. And then many others followed with applications for very demure, very cutesy, and always demure and very mindful. Unfortunately, this happens all the time with viral phrases and trends. People trying to make a quick buck. It happened with hot toi as well. Normally, phrases or slogans can't be trademarked unless they become so synonymous with the business or person that you automatically think of them when you hear it. Think of slogans like, just do it for Nike. You also can't get trademark rights by just filing a trademark application. You get them by doing these three things. First, like just do it, the name has to be distinctive as it relates to your products or services. For example, when you see a brand name, you should be able to easily tell which company made the product or service. Second, you also have to use the name in commerce, meaning advertising, making money, and using it as your brand, or in other words, shouting it out to the public that it belongs to you. And third, nobody else can be using a similar name and selling similar products or services. So before we even get to whether LeBron will lose her rights to the slogan, let's see if she actually owned the trademark rights to begin with. First, it's clear she used very demure, very mindful with her brand and business and in advertising, marketing, etc. It certainly was distinct to her brand as she has 2 million followers, appeared on Kimmel, and inked a Netflix deal related to it. Second, she used the name in commerce for the same reasons I just talked about. And third, assuming nobody else is using anything similar and selling similar services or products after a proper search was done, she would own what's called the common law trademark rights, even without registering it. So if you agree and you think LeBron has to be very demure and very mindful and should win, drop a comment below. And speaking of who's gonna win, let's look at where Bates stands. Bates hasn't used very demure, very mindful yet, which is clear from the type of application he filed. He applied for what's called an intent to use application, which says, I haven't started using the name yet, but I plan to do so in the future. Whether he will or not, who knows? My guess is he won't and just wants money from LeBron. If he does use it as a trademark, it could actually be a big hurdle for LeBron. Filing an intent to use application saves your spot in line. The date that he actually filed the application is the date that the law looks at it, like the day he started using the slogan. The problem here is that the trademark application process takes about 2 years. So what can LeBron do in the meantime? Well, first, I would imagine LeBron's gonna send a cease and desist letter to the Bates and the other filers, laying out the arguments I discussed here and why she owns the rights to the trademark. If Bates doesn't agree and they can't reach a settlement, LeBron could then file an opposition to the trademark with the USPTO, arguing she was the first to use the trademark, and people equate the phrase to her, given her 2 million followers, providing evidence of all the videos, Netflix deal, and appearance on Jimmy Kimmel. Third, she might not do anything. She just might wait and see. Bates doesn't have any possible trademark rights until he actually starts using it in commerce, and he may never do that. It's gonna cost him more time and more money, so LeBron could just play a little chicken here and wait until the application runs out. But my guess is LeBron will send a cease and desist, settle with Bates, and then immediately file her trademark applications for very demure, very mindful, which, if you need to know how to do it the right way, watch this video here.